It can be
Any instruction?
Instruction is there, but it should be considered.
It should be considered. Where is your representation?
It's 46 months.
Which DI?
Nodia. Nodia.
Then this order can go down. It is Nodia only. It is same hobby DI Nodia kora ache.
Get affidavit is kept on.
Yes. Service taken on record.
This matter pertains to, my lord, extension of validity of recommendation in respect of upper primary selection.
Can the same order be passed as was passed in the other matter?
Firstly, I'm opposing this because the extension of the recommendation letter, it varies case to case, whether the candidates came within 90 days, after 90 days, after the extended period, 150 days, etc. Moreover, what fell from the court on the while hearing the first matter, that whether the candidate had mentioned that he or she is a job loser. Now we have scrutinized all the records. In some of the cases, they have specifically said. In some of the cases, it can be clearly inferred because they have at least mentioned that we were working in the 2016 selection process. Some of them are absolutely silent, though they were actually job losers. Now,
how could you ascertain that they were job losers if they do not aver it in? They have.
So 4 candidates have not mentioned even that they were job losers. So each case has been dealt with.
For job
have been passed.
For job losers, are you all right with the order that was passed in the morning?
So in the morning, the
matching vacancies.
So they have certain orders in their support. Now, if we extend the same logic to the person who came, participated, but did not join, and different category of candidates are now getting into the.
The idea is to fill up the vacancies.
And running a shortage of, so that.
If you do not have vacancy, there is no question of permitting any counseling or anything. It is the earlier order was also of the same line. 1 minute. That if the vacancies subsist, available vacancies are there, matching to the qualification, then only. Otherwise, no.
Yes, and my lord is passed similar order, the Concord Park. Subject to the availability of the vacancies. There is the division bench order.
Subject to availability is not the only thing. If I have to process 200, 300 extra candidates in a future exercise where I have no vacancy.
Take up your vacancy list first. Then only
I had submitted
1242 is to be filled up.
On the last day that unless that exercise is complete, then we cannot say that what vacancies we have in our hands.
That was the reason why time limit was not fixed.
Yes.
Right. But then at least do some work. What is to be done?
Let me give one proposal. Since the issue of 1242 has not yet been resolved, which is before the court, let these matters appear in January. In the meantime, let me do a candidate-wise report for each candidate. Let me file it in the form of a affidavit. And then let us treat them candidate-wise. In the meantime, if the vacancy problem is also solved, that can also be solved.
My lord, subject to correction of line learned friend, my lord can pass disposed of by this observing the same. My lord is categorically stated if the vacancy of 5,300 vacancies in their hand. It is not my submission, it is submission before the honorable division bench. Candidates left, my lord, at about 1,300, 1,300 or 1,400, not more than. So they have 4,000 vacancies in their hand, and Honorable Division Bench observed there is no future vacancy, there is no future advertisement in the upper primary selection process. That is why, my lord, Honorable Division Bench passed the necessary direction for conversion. So, my lord, if I am claiming not any, if there is subject verification, availability subject to availability of the vacancy, if the vacancy is matched, they can accommodate it. Since my lord has also passed, division bench is saying job losers are all are job losers. In this candidate, my lord, they may not mention, but
The entire set,
yes, all job
everybody, all
yes,
job
yes,
losers.
all job losers, all job losers. And all reason order is also same.
please
Reason
come.
order they have passed same by observing the same.
New avenue is open, then the number of candidates which will now come before the commission will be enlarged to such an extent, it will be very difficult for us to handle. Absentee candidates could not attend due to a very specific reason.
In furtherance of the direction passed by the court on 4th December 2025, a learned advocate representing the commission submits that the process of filling up the 1420
1242.
1242 vacancies is continuing in compliance of the direction passed by the court.
My lord, figure is here if you lord.
Stop, I do not want the figures. Passed by the court. It has been submitted that the panel in question, where the name of the petitioner featured, expired in September 2025. Stop. At this stage, there is no scope for extending the period of recommendation in favor of the petitioner who deliberately did not join the service in terms of the recommendation. Stop paragraph. It appears that the petitioner is a job loser who lost the job in terms of the judgment passed by the Honorable Supreme Court on 3rd of April 2025 in Civil Appeal number 4800 of 2024. Within bracket, Boishaki Bhattacharya, within bracket, Chatterjee. Now, State of West Bengal versus Boishaki. ঠিক আছে? Stop. Let me see the appeal court's order once. Attention of the court has been drawn to the order passed by the Honorable Division Bench of this court on 25th November 2025 in MAT 1512 of 2025 with IA number CAN 1 of 2025. Within bracket, the West Bengal Central School Service Commission and another versus Orpita Pramanik and others. Wherein the court took note of the fact that the petitioner was impaneled and she came within the listed vacancies of the commission. Stop. But as the candidate was absent on the date of the personality test,
Council.
acha, absent in the process of counseling, personality hobe na, process of counseling, comma, the recommendation letter lapsed. Stop. Under such circumstances, the court directed, not the court, the Honorable Division Bench directed the commission to permit counseling of the said candidate with a rider that the participation in counseling shall be subject to availability of matching vacancies. Stop paragraph. In the instant case, keeping in mind the current jobless status of the petitioner and the fact that the petitioner was recommended by the commission for appointment in a school. Accordingly, the commission is directed to take a sympathetic view of the matter. Stop. The commission is directed to permit counseling of the petitioner subject to availability of matching vacancies only after the 1242 vacancies are filled up. Here,
Yes,
My
absolutely.
lord, counseling, subject to correction, counseling already over. Recounseling, my lord, possibly.
is not required. Recommendation.
Recommendation.
আচ্ছা এখানটা লাস্টেরটা কি বললাম একটু বলুন তো?
The commission is directed to permit counseling of
না,
the
to recommend the petitioner.
Yes.
Only one thing, this should be allowed only after we have completed.
I have mentioned that.
242, but the other absentee candidates who have the orders of court, because they will not be called for counseling. They, if their vacancies are still there,
Yes, yes, yes.
then only will they be called.
Yes.
That at least I think
You think over and all new points will come to your mind. So what is important is matching vacancies. That is the key thing
that is the only thing which is saving me, actually.
disposed of.
My lord, only one thing, my lord, since they have already passed and reasoned order, that, my lord,
Acha.
really consider.
In all the matters,
All the matter, reasoned order.
acha, the impugned order of rejection for extension of the recommendation letter, for extension of the period mentioned in the recommendation letter stands set aside.
Up to
1 minute, one by one, state council's appearance will be required. আপনি একটু থাকুন, 1 minute, Pradeep, take note. এই অর্ডারটা হলো item 17. Same order will go down from 18 to 37. Only the state councils, it will be called on one by one, don't hurry. Only the state council's appearance will change. Order is there. Whoever can take it. ঠিক আছে? Call one by one, 18. State, file দিতে হবে না. State, nobody is there.
I'm for the state, my lord. In
Oh.
item number 18, my lord.
Pradeep, item number 18, state council is there online. Yes, 19, give your appearance, please. And anybody who is not present in court, please do not put in the appearances. 19. Next,
I'm for the petition.
20, দিয়েছে?
I'm for the state, my lord.
Please put in your appearance. Please check up whoever is not there, the list. Yes. 21,
21, I'm for the state.
give your appearance. 22, okay. Nahi. Is Mr. Shahi there? Who has given the name of Mr. Shahi? Who is the junior advocate to Mr. Shahi?
I'm here, my lord. My name is Mr. Supriya Majumdar, my lord.
Yes. Who is the junior counsel?
Mr. Shahi, Your Lordship.
Yes. Where is Mr. Shahi?
Lordship is engaged in some other court.
Then he is not here. Then please do not give the names of anybody who is not here in court. Got it? Next.
My lord, I am for the petition.
Nobody for the state. 25.
The 24
Oh,
I am for the
24.
state, Lordship.
Acha, theek hai,
24 I am for the state.
Is somebody assisting you? Mr.
Lordship,
Boisho?
here, Lordship, Mr. Ghosh is here, Lordship.
Yes, Mr. Ghosh
Mr.
is here.
Minal Ghosh.
Yes, he's here.
24, Lordship.
25. 25, nobody is there. 26.
I am for the petition.
None. 27.
I am for the petition.
Nobody. 28.
Lordship, I am for the state 28, Lordship.
28, record
Mr.
appearance.
Ranjan Saha.
Mr. Shaha is not here.
The Lordship, put to my name.
Your name will be there.
Oh, Lordship.
29. Give your name. Yes. All right, all right. Thirty-one. Give.
For the state.
32.
And I am for the petition.
32, I am appearing for the state.
Give your appearance slip. 33.
I am for
Give. Next, 34.
My lord, in this matter, my lord, Mr. Rausi was appearing in this matter, my lord. Now, my matter is running, my lord. Court number 8, my lord, division bench.
Call him.
What is coming, my lord?
All right, call him.
Coming.
Slip turn in.
Coming.
In.
Yes,
Eh,
my lord,
yes,
coming,
yes,
sir.
yes, yes. All right.
Yes, sir.
34. Who are you appearing for? 34. Somebody else is there.
My lord, but he's appearing with me.
All right.
But
Spelling mistake to be rectified in 34. Record an order, Pradeep.
Accordingly, see. I'm for the state.
Yes. 36.
I'm for the state.
Yes.
it is complete. This
37.
37 is transferred.
Oh, transfer. It's separate matter. 36 is the same order. Yes, 37. Who's for the respondent?
At last occasion, your lordship directed to serve notice upon the state authority.
Who is appearing?
My lord, it is appeared from Ashish Guho and Norin Ghosh. Mr. Ashish.
Mr. Ashish Guho, he was here just now. Wait, call him. His matter is going on.
My lord, transfer application. My lord, I am an assistant teacher in my lord history in HS section. History, my lord, I am single teacher in HS section, but in normal section there are PG categories teachers in histories are there. My lord, so as per the decision of the honorable division bench, my lord, I cannot be treated as a single teacher.
You cannot be treated as?
As a single teacher since there is other
Hello.
rule definition of rule as per rule. If the resultant vacancy is 0. So my lord, the rule is clear. So since there is other teacher,
I did not follow.
my lord, I am the assistant teacher in history in HS section.
Yes.
There are 4 other assistant teacher in history in normal section in the school.
Normal section means?
Up to
Class
10,
10.
up to 10, and
Ah.
they have the PG qualification.
They have the
can-
PG qualification.
They can teach the HS section.
Ah.
So I cannot be treated as a single teacher. My transfer application turned down
No,
by the
I
school
did not
authority.
follow it. You are there in this matter? Item 37?
My lord, notice is there, my lord. I have sent.
I have missed it, my lord.
You missed it. There was a direction upon you to take instruction. Are you sure he's there? He doesn't know he's there.
My lord, there is an order, my lord. Last, there is, kindly see that order.
No, no, he
Earlier
can.
order, my lord.
Earlier order.
No. They have appeared in last, first occasion.
Yes. Ashish Go, Naren Ghosh, Dostidar, I can see your names.
So make it not today, my lord.
Not to
Oh, no,
will not service the.
January.
He
Yes,
needs
yes,
to
they
take instruction.
January. Kindly fixed up a date.
Please come. Learned advocate for the state is not ready with proper instruction. Stop. Let instruction be obtained from the District Inspector of Schools, Secondary Education, Murshidabad, regarding the vacancy position in the subject school. Stop. The not the instruction shall be forwarded as to whether the petitioner is a single subject teacher in history in the school, and whether his application for transfer can be considered or not in accordance with the prevailing rules. Released 5th January. Combined monthly list of January. Yes, next.
Wait, please, your lordship. Order for the petition. My lord, kindly cease my lord's last order date 21st of November.
State. Binoy Kumar Das and Amrita Tiwari. Nobody is there.
My lord, neither any report that has been my lord, submitted to at least my lord served to us.
Yeah.
Eh, da, 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 da.
Where is your friend for the state? Because I see the order that the state was directed to revert with the
Yes.
staff strength of the school.
Because my lord, my submission before your lordship was that though this lady was a single teacher, my lord, but 3 other teachers have joined in the upper primary selection process, and 2 other teachers have already opted. So 5 more teachers will be coming. So instruction of the state was very much required.
Give a phone call and come back. Let it remain in the list.
As your lordship.
Next. Not today.
But could it be a lordship's pleasure, my lord, to direct the state to file a report and serve it on me and come back? I'll indicate this order to my learned friend who is appealing for the state.
None appears on behalf of the state respondents. Stop. The DI, which place?
My lord.
Secondary education, such and such, is directed to file a report
All right, it would
in terms of the direction passed by the court on 21st of
November
November 2025.
5.
Stop.
My lord, DI Paschim Medinipur.
Paschim Medinipur. Secondary education, Paschim Medinipur. Let the report be prepared and circulated
Grateful.
by 6th of January. Release the matter on 3rd.
Grateful.
13th January. Yes, next. Let this order be communicated to the learned advocate representing the state respondents.
Do that.
My lord, item number 39, my lord, similar to 17, but there is a difference, my lord. Here, my lord, pursuant to the order of the coordinate bench, my lord, petitioner's counseling was conducted and petitioner was allotted a school. But because of pendency of the writ petition, official recommendation was not issued. My lord,
Pendency of which writ petition?
my lord, pendency of this writ petition. Petitioner was a job loser in 2019, 10, 11, 12. Petitioner, on that ground, my lord, petitioner was given a chance, my lord. If your lordship kindly sees this, my lord. Petitioner lost her job, my lord, in pursuant to Boishaki Bhattacharya. And my lord, petitioner was also a merit listed candidate in upper primary. But at the time of counseling, she did not appear, my lord. Thereafter, she filed a writ petition for recounseling. The coordinate bench directed you conduct counseling and keep the matter pending. My counseling was conducted and this letter was issued.
That means you have been recommended.
Officially, I have not received the recommendation letter.
Then where from did you get this?
My lord, after counseling, this was issued. The recommendation letter, my lord, is something else, my lord. I have been
Declaration
allotted a school.
as to selection of a school. That means the
School has
candidate
been
has
allotted,
been
my lord.
candidate has been found to be eligible for being appointed even after the counseling process. What is to be done?
Even the
Previous also
they were
eligible.
but they did not get any interim orders.
Right.
The interim order was to allow in the counseling subject to the availability of the vacancies.
Now the vacancy is also been
There
identified.
he was called for counseling, school was allotted, but the recommendation was not issued.
Because of the pendency of the
Yes,
writ
and
petition.
because it was only for counseling.
Right. Now, if the school which has been allotted still contains a vacancy, then let the petitioner join,
Still contains a
because this is your submission. Acha. It has been submitted by the learned advocate representing the petitioner that in compliance of the direction passed by the court, the petitioner the petitioner was permitted to participate in the counseling process, and a school has been identified where there is matching vacancy for providing appointment to the petitioner. Stop. The formal recommendation letter has not been issued because of the pendency of the instant writ petition. Paragraph. As it copy of the communication of the School Service Commission regarding declaration as to selection of a school on attending the counseling session has been handed up in court today by the learned advocate representing the petitioner. Stop. The declaration was signed on the 11th of June 2025. Paragraph. As it appears that a school with matching vacancy of the petitioner has been found to be available, accordingly, the commission is directed to issue the recommendation letter in respect of the petitioner for the school which has been selected for the petitioner on the day of counseling. Stop. The such recommendation letter shall be issued at the earliest, but positively within a fortnight will be all right. 3 weeks from the date of communication of this order. The writ petition stands disposed of.
My lord, only one thing, sir. Accordingly, the appointment letter will also be issued by the authorities. Otherwise,
Yes, the board will issue the appointment
no,
letter.
probably in upper primary money, it is the
Who is-
managing committee of the school who is issuing.
Managing committee of
My lord, let it be.
আচ্ছা তাহলে একটা লাইন লিখে দিন after the order of recommendation after issuance of the recommendation letter all authorities shall take necessary consequential steps in the matter in accordance with law.
Yes, deeply.
One thing my lord recorded in the last line that selected for the petition, but it was actually selected by the petition.
Acha, selected by the petitioner.
Yeah.
Well, it's similar issue. Similar.
Last matter, similar issue.
Similar issue. Mukti Vishwas, that is the
Dr. Patro, item 40,
Yes.
same order is being passed. All right.
I'm for the state law.
Same means the which one? Same,
My lord, just previous matter. Previous matter.
not
comment-
17-1.
No. But it is.
It will be 39.
39.
39. Same as 39.
Same as 30.
All right. Yes.
Great.
For the petitioner, same as 39, recommendation or the allotment of school is there, 11th of June, same day.
How many are there?
Only one.
One more?
আমাদের একটা আছে।
There are several.
আমাদের তো
Many.
একটাই।
I'm
All
carrying
right.
on the matter.
All right.
Great, ma'am.
Yes, disposed.
Same as 39, my lord.
Same as 39, 11th of June.
Yes, yes. Same date. They have made counseling
Alright.
on the same.
Yes, same.
Alright.
হয়ে গেল তো 42 হয়ে গেল তো আহ
42. And read disposed of. 42.
disposed of.
No, what is the date next week?
It is disposed of. 43.
Grateful year.
I am for the petition.
Where were you in the last matter? I didn't see you. Item.
Very sorry, my lord, I could
Which
not
item was
appear in
that?
the earlier matter.
Which item?
In 28, my lord, I was appearing.
I-
But
আঠাশ-
while I was coming, my lord, it
আর
was
ঠিক আছে 28 ওনার নামটা দিয়ে দেবেন তো 28
My lord, in 35.
না না এটা এনার
Wait.
কথা বলছি রঞ্জন সাহা
আরে 28 এ জোসেফ কি বলছেন?
না না he's speaking of something else. He's got
Yes, yes,
separate
I know.
all right, yes, what is this?
Well, I am for the petitioner.
My lord,
What is it?
my lord, in this matter, my lord,
You are directed to submit a
my,
report.
my lord, my lord, there was a dispute regarding the, my lord, certificate, pay certificate, which was submitted by the petitioner. My lord, subsequently, we have found that it is wrong. And my lord, he is entitled. My lord, kindly take please take it into, at 2 p.m., my lord. I shall come with that report.
You
Or
have
not
that,
today.
you have that report with
Yes, yes, yes. In my brief, my lord.
all
it
right, then
is.
not today, tomorrow.
Not today, tomorrow.
এইটা কালকে আর্জেন্ট মোশনে দিয়ে দেবেন তো
He is entitled now, my lord. As his
Right.
lordship desire.
Urgent motion.
Last word. ঠিক আছে?
give a copy in advance to
Yes,
him
yes,
so that-
I shall give you. ঠিক আছে?
I am for the petitioner, Miller. Miller, earlier occasion, order was passed to serve notice to the government leader, and I have served notice.
who is appearing for the state?
Mr. Mahato,
Which Mahato? So many Mahatos are there.
Mr. Lalmohan Mahato and Mr. SP Mahato.
Lal Mohan Mahato.
Sorry, Lolit Mohan Mahato.
He was here some time back. Yes, and who is assisting Mr. Mahato?
Mr. PB Mahato.
Yes, Prashanto Bihari Mahato. Where? Call him.
Next matter, I have the next matter.
You all right, you call him. Give a phone call first. Yes.
Question was about the state to produce the vacancies.
Did you communicate this order
Yes,
to Mr. Mahato?
Yes, my lord, and already I have communicated about the direction discussed earlier occasion.
All right, let Mr. Mahato come. Let us see.
Grateful, my lord.
All right, 45.
My lord, I am for the state. Before my learned friend starts, my lord, your lordship directed the DI of schools, my lord, to file a report. Now, my lord, I have taken instruction, my lord, that DI of schools, my lord, has undergone and surgery. If your lordship grants some time, my lord, so that I can come back with the report.
Well, may I?
45 to
45, I am for the private respondent. My lord, it is mainly challenging the removal of TIC. The teacher says that he was TIC.
You are the TIC?
No,
No.
I'm one of the assistant teacher. Against me, several allegations are there. Respond number 10. Only kindly see this removal from TIC has happened in terms of the direction passed by the DM. Kindly see the allegations. The direction, why it has been done. Kindly see for, kindly see for once
52
why it has been done.
Previous matter, order was passed by this honorable court, page 52.
For his resumption of
Prior to that, you also can
Now,
see.
my lord, I am
What
compelled
was
to
the order
say,
passed by this
I
court?
am compelled to say, in the midday meal scheme, he has conducted ranked illegality. Kindly see the DM's order for once.
Yeah, Pradeep.
As per the instruction of the
Learned
DM, he
advocate
has been
presenting the state respondents. Seeks extension of time to file the affidavit. How soon can the affidavit come?
Report.
Report. All right,
Oh,
report.
এটা আছে আপনার কাছে।
At least 2, let it be up. My lord.
After the vacation?
New Year.
এই আমার নামটা response number 10.
13th of January.
May I take back this?
Yes, please take back.
I've called Mr. Mahato, but he's not picking up the call.
All right.
I'm again calling him.
Yes, next.
46, my lord, I am for the petitioner. This matter relates to, my lord, interest on the delayed payment of, my lord, ROPA 2019, but petitioner was late. Petitioner filed after 3 years. Well, now, last occasion, your lordship, my lord, directed the petitioner to be present, but he do not want to proceed now because he is suffering from congest. He has given me that very 5% interest, and that is why he's not interested.
Had he come, I would have sent him to jail. That is the reason he has not come.
The next matter, petitioner has come, but
I follow. The court understands what happens.
no, he is giving
Yes,
that.
yes, very well, not pressed. Next.
Forty-seven, my lord, the same order. But I don't know, my lord, here also, my lord, petitioner was late. In 2021, he received the amount, June 2021. And he's filed the case on October 2025.
Why?
My lord, petitioner, according to petition, he was ill. He was totally alone. Yes.
He was ill.
Yes.
Right.
He is not physically well. Your lordship can, my lord, ascertain from.
Ah.
I 48, I am for the petition.
Yes.
My lord, here is the vacancy report.
My application was recommended by the DI to the School Service Commission, but I have my lord, handed over, my lord, the last occasion that the School Service Commission intimated there is a low rank of the low students, my lord, in the school. But the particular subject there, you will also kindly see the last order.
No, what is the
DI
vacancy position?
DI Kolkata is a party I have served upon the DI Kolkata. There is no teachers, my lord, in the particular
The
subject.
number of sanction posts is 12 with 7 teachers at present. 100 students. What will the teacher do over there? Huh?
কত স্টুডেন্ট আছে কত টিচার
100 students.
Teachers.
7 teachers.
7 teachers.
Ah.
But no, there is no geography teacher.
There is no student.
100 teacher.
There is no student. What will the teacher do over there?
Now I am, my lord, I have instruction, my lord, specifically not, my lord, written instruction. Now the vacancy has been reported to the second SLST, particular my subject. Lord, the on hand, my lord, they communicated that there is a low student. Now the vacancy has been reported. This is, my lord, the no. Geography teacher is required.
A teacher is required. There is no geography teacher I can see. There is no geography teacher. How does the school function without these teachers?
There are no students, madam.
That is the reason.
There are three groups. One language group, social science group, and science group. But a history teacher can also teach the geography.
No.
Just 5 to 8, 10 marks.
The high school.
There is 5 students reading in class 8.
What is the use of keeping a teacher?
Your Lordship, Your Lordship, I'd like to take a leave of this court for filing an urgent matter. It is regarding an SSC matter where Supreme Court had directed in the year 2016 that untainted teachers can continue with their jobs till 31st December, utilizing the rule laid down by the Supreme Court. And now, Lord, after 31st December, we do not know as to what will happen to us or our jobs. So kindly,
What is your prayer?
prayer is to look after the matter, Your Lordship.
Look after the matter means? What does look after the matter mean?
Kindly hear me once.
Yes, I'll hear you. But why have you come now? This is not the time to mention. Where from are you coming? Are you a practitioner, regular practitioner of this court? Are you? Is mentioning allowed at this point of time?
Lord, I was told that after a break, there's a
Who told you? Somebody must have told you. Who told you? Come tomorrow morning. All right? Yes. Yes.
The petitioner,
The staff yet to receive terminal benefit.
is a group D staff, yes.
Yet to receive terminal benefit. Why? Give a copy to him.
I have seen, Melody.
You've seen? What is the
DI has
instruction?
requested the school to forward. Online application has been submitted. Now,
When?
as per the objections, my lord, the manual file has not yet been received by the DI. That is I have instructions also revealed. You know, so direct the DI, my lord, the school, my lord, direct the school to forward the pension papers to the DI.
You retired on 29th of February 24 and you submitted your application only on 3rd of January 24. Why? You are required to submit your application nearly 18 months back.
The group D staff, my lord, I don't know, my lord.
And then you will come seeking interest on account of the delayed payment of terminal
Of the
dues.
institution should, my lord, assist, my lord, the group D staff, he doesn't know anything.
He knows everything.
Page 16, I will see, my lord, the online application I have.
Now the group D staff is better acquainted than the class 1 officers.
And there was no complaint regarding overdrawn or allegations, nothing.
All those comes later on. Objection by the school in July. School returned back to the petitioner in August. Then the applicant forwarded his pension file to the head of the institution in September. All 1 month, 2 months difference. The school did not forward the pension paper to the office. Please come. Use the report forwarded by the District Inspector of Schools, Secondary Education, South 24 Parganas, signed on 19th of November 2025. Stop. It appears therefrom that the petitioner, a class 4 staff within bracket peon, retired from service on 29th February 2024, but his pension file is yet to be made ready. Stop. The records reveal that the petitioner submitted his pension application with other papers to the school authority on 3rd January 2024, and the school forwarded the same to the office of the DI. Forwarded soft copy of the same to the office of the DI on 14th of June 2024. certain objection was raised and the file was returned back to the school on 13th of July 24. Stop. The school authority returned back to the petitioner on 1st August 24 and the petitioner forwarded the pension file to the head of the institution on 4th of September 2025. Stop. Till date, the school authority did not resubmit the pension papers of the petitioner to the office of the DI. Stop. Paragraph. Request was sent by the DI to submit hard copy of the pension papers of the petitioner to the school by a communicating memo dated 18th of November 2025. Paragraph. From the sequence of events mentioned herein above, it appears that the movement of the pension file of the petitioner initiated practically after his retirement. Stop. The same ought to have been done prior to the retirement of an employee. Stop. The school ought to have been more vigilant and made the pension file of the employee ready well in advance of the date of superannuation. Stop. Paragraph. As the employee has retired in February 2024, accordingly, the District Inspector of Schools 2024, and it is high time that the terminal benefits should be released in his favor. Stop. The District Inspector, as accordingly, accordingly, the District Inspector of Schools is directed to follow up the matter with the school authority for making the pension file of the petitioner ready. Stop. All steps shall be taken to ensure that the terminal dues of the petitioner are released at the earliest, but positively by 31st March 2026. Read petition disposed.
The one directions
Section
upon the DPPG on headline 9
the District Inspector of Schools shall also forward all papers to the Director of Pension, Provident Fund and Group Insurance for issuance of PPO in favor of the petitioner. তারপরে বলবেন যে shall ensure that the retirement dues is released within 31st. ঠিক আছে, এই লাইন ডিপিপিজি কে আগে দেবেন, তারপরে আউটার লেটার দেবেন. Yes.
I am for the petition. Kindly see the last order passed by your lordship.
Yes.
The petitioners, my lords, after taking the permission from the managing committee, he enhanced his qualification.
1 minute. How is this matter different from Utpal Kanti Karan?
I also have Sanjay Mondal, your lordship.
Sanjay
passed the
Mondal
order.
is there.
Your lordship passed the order, madam.
Yes.
Here. Lordship, the petitioner did not take any prior permission. He has applied before managing committee, but the search has never been forwarded to the DI.
Is it his fault? Then?
But the thing is that the search, the school authority is also not present.
Doesn't matter.
But
is it the fault of the petitioner? if the school does not forward it to the DI's office?
Should kindly come to the instruction option.
Yes, what does it say?
Prior permission is required or.
That is what you are submitting.
But or the resolution of the managing committee to be forwarded when the managing committee has taken any decision. But neither such has been forwarded by the petitioner.
Tell me, is this the fault of the petitioner? Why will the petitioner not get the benefit?
GI has no law. Prior permission is very much required in that case. And the Uppanti is that it's the after he has get the appointment in the honor graduate. After that, he did the complete
Please come.
course.
The petitioner seeks higher scale of pay on enhancement of his educational qualification. Is there any rejection?
Yes, madam.
Yes.
Page
Page 98, madam.
His prayer stood rejected by the District Inspector of Schools, Secondary Education, Purva Bardhaman. The communicating order dated 31st December 2024. On the ground that the petitioner did not obtain any prior permission of the concerned District Inspector of Schools. Stop. (593) was taken up into consideration, isn't it, Geo?
Yes, ma'am. Paragraph number 179, the larger bench, madam.
Larger bench.
Yes, ma'am.
Acha.
Set aside the 590.
That has been set aside.
Madam.
Geo 593 is 6 number থেকে Geo 593 SE within bracket B dated 21st November 2007 has been relied upon for rejecting the claim of the petitioner. Stop. The applicability of the aforesaid government order was considered by the special bench in the matter of Utpal Kanti Karan and others versus State of West Bengal and others, reported in 2024 SCC Online Cal 1274, wherein the court was pleased to set aside the said government order. Stuff. The petitioner obtained the prior permission of the school where he was teaching prior to taking admission in the which course?
MSc.
Master degree course. Stop. According to the DI, the resolution of the managing committee was not forwarded to the District Inspector of Schools. Stop. Paragraph. Whether non-forwarding of the resolution of the managing committee according prior permission to a teacher to enhance his educational qualification will disentitle the teacher to receive higher scale of pay was considered by the court in WPA 29958 of 2016 in the matter of Narayan Chandra Borai versus the State of West Bengal and others. And order was passed by the court on 19th March 2024, holding that the obligation of a teacher comes to an end the moment the teacher applies before the managing committee of the school for obtaining prior permission for enhancement of the educational qualification. Stop. Thereafter, it is the obligation of the managing committee to forward such resolution to the concerned DI for obtaining prior permission. Step. Paragraph. The court in WPA 21965 of 2025, Sanjay Mondal versus the State of West Bengal and others, passed order on 14th November 2025 in similar set of facts directing the concerned DI to take steps for grant of higher scale of pay. Paragraph. As it appears that the facts of the present case are similar to the facts of the case of Sanjay Mondal within brackets Supra, comma. The instant writ petition is also disposed of in the same lines. Stop. The District Inspector of Schools, Secondary Education, Purva Bardhaman, is directed to take necessary steps for grant of higher scale of pay to the petitioner in accordance with the relevant rules. The earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. The impugned order of rejection dated 31st December 2024 stands set aside. All consequential benefit shall be released in favor of the petitioner without any further delay. Instruction written with the records.
my lord, I for the petitioner. The matter relates to, my lord, delayed payment of interest. Here, my lord, your lordship's query, my lord, is a died in harness case. And your lordship, my lord, the date of death of the employee, my lord, on 26th November 2019, and the PPO issued on 1st December 2022. Your lordship has passed one order from the due date. My lord, that is why, my lord, I am relying on it.
I got the instruction.
Please give.
Due to lack of document.
Please give. Forward it. The teacher expired.
On 26th November 2019. Now,
Right.
para 3, your lordship, that it was submitted on 22nd July 2020. Well, within 6 months.
So, yes, it was submitted.
More or less 6-7 months.
6-7 months. And then it went up to the
Well, authority to getting well at past service continuation.
It took time.
Yes.
So, what can be done?
Well, for that, well, para 4, para 5.
19, and then it was 22.
Yes.
There is not much delay.
Well, from 2020 to 2022. 2020 to 2022.
18 months is the usual time for making the pension file ready.
That is for the no, not 18 now. Now it is the digitally, it is only 1 year.
1 year, 12 months.
6
now
months
it
before
has.
retirement, it has to be submitted. 6
No,
months.
Not 6 months. It takes.
No, my lord, it was 6 months. From 2017,
Hmm.
it is cut short down to 1 year before the retirement. He should be given notice, and before 6 months, it has to be e-pension file has to be submitted.
All right. Now this teacher died in harness.
Yes.
So the papers were not there. Obviously, it could
Papers
not have
are there
been.
in the school. Well, in the died in harness case, there is no intentional delay on the part of the employee concerned because he already expired.
Passed away.
Naturally, it is up to the school authority to do.
Yes.
My lord, admittedly, 22nd July 2020, my lord, it was submitted. So, my lord, on and from 2020, petitioners has no role to, my lord, get this, my lord, all these files from this office to pillar to post, he cannot, my lord, run.
That is all right. But then
and the rule says, my lord, it is due and payable from the following the date of death.
Following the date of death,
yes, that sometimes should be made.
superannuation is
Yes,
all right.
Yes.
Candidate
Yes, yes.
superannuates is all
Yes,
right.
I
Death certainly it cannot be.
cannot be.
So you have to give that much of time.
So on and from, my lord, July or August 2020, I am entitled. That is my only submission.
It was submitted in July. How
Yes.
can you get it 6 months if you take
Depends,
it?
sir. Within 7 days, it is now, my lord, getting the benefits.
No, this 10 years CAS benefit had to be given.
That
Can you
is
please
given by
come?
the PSA pension sanctioning authority. And that is all the records are now digital, my lord.
The wife of the petitioner was serving. No, serving na. Wife of the petitioner, who was a teacher, died in harness on teacher of an approved headmistress. Was an approved headmistress of a school who died in harness on 26 November 2019. Stop. The e-pension payment order has been issued on 1st December 2022 and payment actually stood disbursed on 19th December 2022. Stop. The petitioner seeks interest on account of delayed payment of the terminal dues. Stop. The District Inspector of Schools, Secondary Education, Purva Bardhaman, has forwarded a report wherefrom it appears that the pension file of the teacher was initiated and submitted online to the head of the institution on 17th July 2020 and hard copy submitted on 22nd July 2020. Stop. For providing the benefit of past continuous service of the for providing post facto approval of the past continuous service of the teacher for CAS benefit, comma, there has been delay the post facto approval of the CAS benefit was accorded by the Deputy Secretary, Government of West Bengal only on 21st September 2022, and thereafter the PPO was issued on 1st December 2022. The paragraph there, the DI has mentioned that without the post facto approval of the CAS benefit, comma, the pension sanctioning authority was unable to proceed with the pension file of the petitioner. Paragraph. As the teacher died in harness, accordingly, the pension file of the, accordingly, her pension file was not made ready earlier. The process for initiating the pension file started only after the death of the employee. On a perusal of the report forwarded by the District Inspector of Schools, comma, the court is of the opinion that this is not a fit case for directing the authority for grant of interest on account of delayed payment of the terminal dues. The writ petition accordingly fails and is hereby dismissed.
On and from 20 to 22, my lord, respondent has taken time.
Next.
$52 also, my lord, died in harness. Report us. 28th December 2022, my lord, died in harness. And my lord, PPO issued on 2nd November 2023.
Not even a year.
Yes.
Less than a year.
Yes.
So, what is the instruction? Why? Who has not given you the instruction? Which DI? How can you get the instruction within 1 week? Because you sought for instruction and you did not get it. Bring the instruction. Please come. The petitioner seeks interest on account of the delayed payment of the terminal dues in favor of her husband, who expired while in service on 28th December 2022. It appears that PPO was issued on 2nd November 2023. The paragraph here, the District Inspector of Schools, Secondary Education, Bankura, is directed to forward a report explaining the delay in issuance of the PPO. Released 5th January 2026.
Great.
My lord, item number 53. In this matter, my senior Mr. Dibyendu Chatterjee is engaged before another court, my lord, praying for not today.
Why don't you proceed?
My lord, as per our instruction, he will do this matter, my lord. That is why. Praying for just one, not today, my lord.
Where is the advocate on regard?
Is it Meenakshi Verma?
You are questioning the
No,
court.
no, my lord,
The
no,
advocate
no.
on record.
I'm not directly engaged in this matter. That is why, my lord. Pardon.
What is the matter? Who is for the respondents?
For the respondent number 8.
Respondent number 8. So many respondents.
Private respondent.
Group of private respondents. How many petitioners are there? 25. What is the issue? What is the issue? Prayer. What is the prayer?
Prayer is rather defective.
Defective.
Yes, because they have prayed for a direction upon the Board of Primary Education to allow the petitioners in the
Primary. Is this a primary?
No, but school service
Full service
commission
commission.
authority.
It is upper primary mentioned.
You can see page 33.
Yes. West Bengal Board of Primary Education. Where is the council? Why is the SCC coming in then?
So it is with regard to SCC.
Then primary must be wrong.
Yes, that is maybe a result of copy paste.
Maybe. Appointment. I see they are commanding to give appointment to the petitioners as assistant teacher of upper primary level. Recruitment process of 2016.
My lord, I am appearing on behalf of the respondent number 13, my lord. My lord, I think, my lord, the respondent number 13 ought to expunge. Why? My lord, this says respondent number 13 is age barred, overage. I am showing just one page, my lord. That is
Wait, the petitioner is not here.
Oh, sorry.
My lord.
Edit commanding to call the petitioners for counseling process. But what is the process? What is the stage?
The stage is the final expired.
September.
Yes.
Ah.
And they are now paying to participate in a personality test with regard to this people
Long back.
That is the reason repeated adjournments are sought.
No, my lord.
No.
And not only that, on factual aspect also that is wrong.
How many court fees? Shailesh, please check. How many court fees paid?
Okay. 25 petitions, my lord.
This is the respondent's wakalatnama has come in. Petitioner, only one court fees paid.
My lord.
Please come. Instant writ petition has been filed by 25 petitioners. Look at the cost title. How it has been typed and printed, all caps, till 21, and thereafter addition of parties. So they have come in small letters. Achha, 25 petitioners by submitting only one court fees. Stop. Leave is granted to the advocate on record of the petitioners to submit the deficit court fees prior to the adjourned date, released on 5th January 2026.
My lord.
Record appearances of private respondents, state, commission, everybody.
Thank you.
Yes, he is engaged. Yes, so what is to be done? Passover. What is your prayer?
No, this is a second SLST matter.
Second SLST matter. Why are you so special?
In 2000,
You come this side. Otherwise, they are not getting. You take this microphone. Yes.
my lord, in 2013,
Hmm.
I was appointed in 12th RF in person to the recruitment process to 12th RLST. Thereafter, I was continuing my service up to 2019, and I appeared in 2016 recruitment process, and I was a successful candidate, and I was appointed in 2019. But thereafter, I apply in SSC portal, and I was transferred in 2021. And thereafter, I appeared in the recruitment process of assistant headmaster, which is a separate. I think because in my lord, I want to bring the notification to draw your attention at page number 26, annexure P5. 26 P5.
Yes.
Para 2. In para 2, headmaster or headmistress or teacher in charge, as the case may be, as directed by the school authority after receiving of prior permission from the district inspector of schools secondary education for filing up of the post of assistant headmaster, assistant headmistress shall notify and collect applications of such approval and willing teachers of his or her institution who are graduates with honors, including special honors or holding master
No,
degree.
what happened?
Thereafter, just now, 2 years course and having 5 years teaching experience in a junior high school, secondary institution. This is the my crucial point. I want to apply for being appointed as assistant headmaster, I have to comply 5 years teaching experience. My teaching experience was calculated on the valid service.
What? Your?
My teaching experience for 5 years was calculated at the time of being appointed as an assistant headmaster on the basis of my valid recruitment. From since I was appointed in 2013 in person to the 12th RLST. That is why I was a valid teacher up to as I was discharging my duty up to 2019. Thereafter, in 2016, I was appointed in the 2016 panel, which has been already cancelled. Therefore, I think, my humble request before your lordships, my assistant headmaster recruitment process based upon my valid service.
Yes.
Not on the.
What is your prayer?
Oh, I have been issued the letter to go back to my previous service. But it is not as per constitution. It has no validity.
Implementation of an order passed by the Honorable Apex Court in
He wants repatriation.
Repatriation, but my lord, he has been repatriated to his original place of posting
And not
in
as the head.
compliance of the order passed by the Honorable Apex.
Not as the headmaster.
That, yes,
He wants to be repatriated as the headmaster.
in the post of assistant.
No, I have been repatriated to the previous original service, but it is, I think it is unconstitutional.
Unconstitutional.
My right has been I have been aggrieved by that order.
By that order, where is that order?
Order I have annexed my annex of P12 page 39. No, madam. Wait, this is my representation. Annex of P12, my lord.
Yes. Has the time period expired for you to join?
Yes,
What
expired.
is it has expired?
Yes, expired. I have also joined to that in person to
joined.
the yes, without prejudice my rights and
All right.
contention. I have joined, my lord, to save my life.
Yes, certainly.
But my rights has not been snatched, my lord.
Yes, the commission. Recommendation is letter is by the commission. He was serving in the post of headmaster. You recommend him as assistant teacher. No, or whatever. Even if it is assistant headmaster, now he is the assistant teacher. So the grade changes.
Yes, madam.
Then you will recommend him to the post of a peon.
Yes.
Are you sending the teachers back to the same school? You are not. You send him to somewhere else.
That the state has to provide us with. We do not know which batch to send.
You do not know anything. You recommend a teacher to the post of a peon. That is your work.
Whatever has been provided, we have recommended to a post of a teacher only. The difficulty for us is the assistant headmaster's post, whether he, first of all, we do not know what way, whether he was a property assistant headmaster or what kind of the way he was.
Without knowing anything, you do everything.
Available with us, but has taken up other matters in similar way. We have done that thing.
No, this is something different.
Yes,
This
yes.
is not one of those regular matters which are taken up where the teachers are repatriated to any school you feel like.
Grateful.
The court has not interfered in any of the matters. But here he is an assistant teacher, headmaster.
Yes, ma'am.
And you recommended him to somewhere else. Find out what is to be done.
Yes, my lord.
Please do.
Yes, madam.
The petitioner. The petitioner has been repatriated. Now, the petitioner was serving in the post of assistant headmaster, headmaster in a school when his service, when he took up the job of assistant teacher, being successful in the first SLST, 2016. Stop.
Prior to that,
After the 2016 selection process stood cancelled by the order of the Honorable Supreme Court, the petitioner has been repatriated in terms of the Supreme Court's order, not in terms, in accordance with the Supreme Court's order, to a school in the post of assistant teacher. Stop. He is aggrieved by the same. Stop. He submits that he ought to be appointed in the post of assistant headmaster. Stop. The learned advocates representing the state and the commission are directed to revert with instruction. Stop. Next. Be it recorded that in terms of the letter of recommendation issued by the West Bengal School Service Commission, the petitioner has joined the school without prejudice to his rights and contentions. Stop. 5th of January. 6th of January.
grateful deeply.
Yes.
Lord, here, my lord, the case is, my lord, petitioner was initially appointed as a part-time teacher. My lord,
Is this also SLST matter?
No.
Or separate? The respondents are there?
Yes.
All right.
Lord, petitioner was appointed as a part-time teacher in a school. My lord, subsequently in 2014, petitioner left the job and petitioner has got an appointment in a permanent post in 12th Dara list and he got. Thereafter, my lord, what happened? Some of the colleagues of the petitioners in that school filed a writ petition that you give me equal pay for equal work because we are serving and doing similar duties. My lord, the single bench passed an order, said that no, there should be an equal pay for equal work. an appeal was preferred by the state, my lord, and it was modified. The division bench modified the order to the extent that up to from 2010 to 2030, they will get this equal status of basic pay, equal pay for equal work. And SLP was preferred. My lord, in the SLP, it was dismissed, but Supreme Court made an important observation that all similarly situated candidates should be given this benefit. Now, my lord, I worked till 2014. From 2010 to 2014, I worked. I won the arrears from 2010 to 2014. My lord,
Arrears means the enhanced amount.
enhanced amount. My lord.
All right. Did you make any
Yes,
representation?
yes, I made one representation.
That is pending.
Yes, my lord.
Oh, you want consideration? What is, did you
64
get an instruction? No.
Consideration. 64 এর আছে কনসিডারেশনটা বলি
Please come.
রিপ্রেজেন্টেশনটা কনসিডারেশন বলি
The petitioner
টাইম লিমিট
seeks payment of arrears salaries in terms of the judgment passed by the Honorable Division Bench of this court on 3rd September 2020 in Mat 1221 of 2019 within brackets State of West Bengal and others versus Anirban Ghosh and others, and the order passed by the Honorable Supreme Court in special leave to appeal within brackets civil number 14355/2021 and page 64, page 2809/2021. What is the transfer petition?
Two matters were taken up together, my lord. The main order is this, my lord. At page
59.
59. Relevant is 60. Both the matters were taken up together. A transfer petition from the court.
Transfer petition orders appears on page number 61. Same, it was dismissed.
2021
Same.
and the order passed in the transfer petitions within brackets C number 1288-1297/2022. Stop. It appears that a representation through the learned advocate was served upon the Commissioner of School Education in August 2025. But there is no response from the authority till date. And is the commissioner the competent authority
Yes,
to
my
look
lord.
into it? Show me.
My lord, because salaries, unless commissioner passes an order, DI cannot. my lord.
Secretary School Education Department to decide the claim. Secretary, it's the Secretary School Education Department. The direction has been passed. It appears. Revision bench passed order, page 57.
Yes, that direction that this petitioner should be given equal pay for equal work was upon the secretary. Thereafter, my lord, executing authority is the commissioner of school education, my lord. I can also have, give a fresh representation to the secretary also.
দুজনকে দিয়ে দেবো।
As it appears that the representation filed on behalf of the petitioner is pending consideration before the Commissioner of School Education. Accordingly, the instant writ petition stands disposed of by directing the aforesaid authority, being the respondent number 2 herein, to take a decision on the petitioner's representation, strictly in line with the judgments mentioned herein above. After giving reasonable opportunity of hearing to all the necessary parties, at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop. A reasoned order shall be passed and communicated to the petitioner immediately thereafter. Step. If the prayer of the petitioner is allowed, comma, the necessary consequential steps shall be taken without any further delay. Stop. Learned advocate for the petitioner is directed to forward a copy of the representation along with all other supporting documents to the aforesaid respondent at the time of communicating the order of the court. Disposed. Service is taken on record.
I am for the petitioner.
ঠিক আছে দিন যে জাজমেন্ট স্কুল আছে হ্যাঁ
But I shall be
I made 16 and 25, which was
comparative
yes,
chart.
yes,
All right.
because I begin with this chart itself because that will give it's I made it's complete neutral chart, not for whether for 25 or whatever is there. If Lordship, before seeing in detail, if Lordship kindly take the next page, the crux of it, if I begin with that, the main differences, the 6. The written examination, earlier, it was 55%. Now there is a 5 marks more, 60. Now non-written component, earlier it was more, 45%. Now it has become 40. Now this maximum advantage from academics, this I will show from the first page itself. Now one interesting aspect, interview shortlisting for 100. Earlier it used to be calling 140.
Yes.
Now it is 160. Now Lordship kindly take the first page itself. First 55-60 I have already said. Now another major changes in the academic qualification. Earlier the marking was 35 in 2016. Now that has been reduced to 10. Now prior teaching experience, earlier it was nil. Now it is 10, maximum 10 marks. Now personality test interview, earlier it was 10, now also 10, same. The lecture demonstration, earlier it was not there, now it is there. So if Lordship make it a two broad category of written and non-written component, Lordship will see that in the written component, there is a hike. Because why I want to little emphasis on the written, because written is a completely level playing field. And the non-written is something whatever someone has done past, whether academically and others. Now regarding this, kindly see Roman 3, the which were the things which were there in 16. In 16, my lord, there are 3 buckets like 25, but that buckets was supposed to be filled up by Madhyamik, then higher secondary, then graduation, B.Ed, and total was 35. Now if Lordship kindly compare it, next page, this is not sorry, that is not next page, because there that I placed it is not here. Now it is only 10 marks, 3 buckets, and based on it's a graduation or post graduation, whichever is higher. So a major shift is that Madhyamik, higher secondary, and the marking for the B.Ed which were all out, which were there in 16. That's the major shift. So therefore, that 35 marks was there. Now it has come down to 10. Prior teaching experience, that I need not say. Now, based on that, if Lordship kindly take the Roman 7, that what I intended to submit. First is under the 16 rules, written examination carried 55 marks, under the 25, 60 marks. So for a fresher, the most powerful component is the written test. But that's a general statement. So this is stronger than under the 16 rule. Why I was trying to, my lord, also focus on this, because their entire focus is on somehow disturbing the equality by 10, because regarding educational qualifications others, this is not the grievance that they have agitated, though I have given whatever is the plus minuses or the changes, but their grievance is on that. Now if Lordship look at that grievance, that today you don't get 10 because you don't have experience, because you are a fresher, one immediate reply could be, yes, you don't get that, but you also have 5 more if you are a better student because of the competition. That's a written marks. Just I would say, if someone says that, there is a possibility of the opposite way of looking it also. Now, non-written marks have actually reduced. Their under 16 rules, non-written components total 45 marks, academic 35, and personality 10. Under 25, this non-written components totally now only 40 marks, educational 10, experience 10, interview 10, and lecture demonstration 10. So this is, I would say, the major change. Now, 2025 rules do not increase discretion or arbitrariness. That I tend to say that it's not that interview marks is increased, where a subjective satisfactions of someone, or there is a possibility of arbitrariness, that is not there. Interviews, it remains same. C, experience marks are strictly capped at 10%. This part I am not making submission because this I already made submission. Now D, freshers compete on more written centric model, which I was trying to say that the non-written component got reduced little and written component got increased little. So therefore it is more. Now E is that shortlisting part, that now because of 100 it becomes 160, so chances
of being shortlisted increases.
So therefore if a question is put to me, is it different, I would say yes, substantially 25 rules are different. It's not identical at all, but that substantial difference, if I try to look at from a neutral point of view, is towards, the answer is F. I've just put it in writing, F. The classification is valid under Article 14 if there is Roman 1 an intelligible differentia, and number 2 a rational nexus with the object sought to be achieved. Now intelligible differentia, the candidates with teaching experience form a distinct class from freshers. So therefore this is clear, they are different. Now question is whether nexus, the nexus part, teaching experience improves classroom management and pedagogical skills are direct link to the object of selecting effective teachers. But it would be very difficult to prove it, but that's the
admittedly experience matters.
Yes, but that's I'm saying that for that I may not be able to prove by any tangible thing, but that's something which most of us, we recognize it. Now both limbs are satisfied, and then I just put it that the 2025 rules are not harsh to freshers. The written examination has become more dominant, non-written component has been reduced, and the experience criteria is strictly capped at 10. The same ceiling as educational qualification can be entirely neutralized by performing well in the written exam. That's a stiffer part for the freshers, that you have to be better students, not everyone. The interview shortlisting ratio has been widened. So therefore, a better opportunity to reach the interview stage. So that's the plus for the freshers. So classification satisfy both the limbs, that's the nexus part and the intelligible differentia. And consequently, the allocation of 10 marks of prior teaching experience under 25 rules, that was my respectful submission. That so therefore, one sentence, yes, it is different. Substantial difference is there, but that difference is I would say tweak, which I would say gives more importance to experience, which can be said to be synonymously a life skill and more intelligent, better students. There was one specific query. There was a specific query by your lordship. It was not to me to. There was a specific query to Mr. Mitro. Lordships made the query from the Honorable Supreme Court, specific directions that it will not give them any advantage. Well, I was reading that, so I thought there was an interpretation possible. So I just thought that I should make that submissions. 3-4 pages. একটু দিয়ে দিন এটা মতো পেজটা বলবে দেখে দাও দেখে দাও
রাহুলের অপোজিশন 4টে আছে একসাথে
একটা
না এটা না মানে ভলিউমে করে ফাইল করতে হয় দিস ওয়ান পুরোটাই
এটাই হ্যাঁ পেজ 229টা দেখে নিন যে ভলিউমটা 229 ভলিউমে আছে 229টা ভলিউমটা অ্যাকচুয়ালি আমি সফট কপিতে ইউজ করছি তো আমার কাছে since I am using the entire PDF copy, for me it is
easier.
No, not easier. It is difficult because, in fact, there was a thing. This I am seeing in a one-dimensional less. When we touch this book, we are in the 3 dimension, and I think connection with the memory and the brain is much better. I say that in the entire PDF, I don't have a volume, so that's why I was trying to understand the page number is 229.
Yes.
And Lordship's query was on page 230, 17-4 order. Because this, well, I have observed that there are 2-3 occasions Lordship wanted to know this. That we clarify, Lordship has got, we clarify that this order shall not be read as conferring any special right or advantage on the aforesaid teachers insofar as fresh recruitment process is concerned. Therefore, this 17-4 order clarifies that it cannot give any special advantage. So I was, because apparently it is very much a negative point if I appear for these candidates who appeared. So I was trying to understand what exactly the order says so. The order basically, may I just first say, thereafter I will show. After this Boishaki judgment, state filed an MA, saying that 1, 2, 3, 4 reasons kindly allow the assistant teachers to continue. Just only for that. And that was the prayer, just for a look, this was the prayer. The exact prayer was permit the appointees not found to be tainted to continue service till the end of the academic, because they were in a complete mess, the state, how they can run the school. So that was their prayer. In that context, first part was, Lordship kindly see that if kindly take the ordering portion, first paragraph. We are inclined to accept the prayer made in the present application, so far as it relates to assistant teacher for classes 9, 10 and 11, 12, not found to be tainted, subject to the following conditions. The condition number 1 was the advertisement to be made. Condition number 2 was the examination and the entire recruitment process shall be completed by 31st 12. Condition number 3, Board of Secondary Education and West Bengal Central shall file their respective affidavits. Then state board. So let us not go that technicalities. My learned friend was correcting me that this application was made by the board.
Whoever, no,
I say that it makes the same thing. Ultimately, it's the order of the Honorable Supreme Court. 4, in case the advertisement is not published by 31st May and the affidavits are not filed by that date, appropriate orders will be passed by this court, including imposition of cost and vacating of the present order. Vacating of the present order means first line of the order, that allowing the prayer filed in the MA. After that, this is the importance. So in the context of 17th April to December, the continuance of the teachers, now Lordship read, we clarify that this order shall not be read as conferring any special right or advantage on the aforesaid teachers in so far as the fresh recruitment process is concerned, meaning thereby, yes, Honorable Supreme Court are allowing the teachers to continue from April to December. But that continuance, to my understanding, cannot be counted in any form, not even in the form of an experience, not even in any other form that I was there, any kind of right, nothing. So therefore, this word, we clarify that this order, therefore this order of allowing, it will not give any special right or advantage. This advantage means this continuance after 17/4/2025 up to this
31st
December. This has got nothing to do with the past experience of the untainted or not specifically found to be tainted. How that can be also found, consistency Lordship might see. Kindly take page 376. That is in the 3rd volume. Another order of the Honorable Supreme Court.
Yes.
Well, this is an order dated 29th of August. So on 29th of August, in fact, I would be relying on just the order passed on 21/8, but that is quoted here. That's why I'm showing the one document. 376, kindly see. By order dated 21/8/25, passed in SLP number such and such, this court directed, well, this is the order 21. We direct that in the meanwhile, well, this is important, all selected and appointed, it is not for everyone, it is not for all participating, untainted candidates who were permitted to continue in service, that is, this permission was based on 17/4, I just placed, till 31/12/25, shall be allowed to participate in the fresh selection process without insisting upon their complying with the newly introduced eligibility criteria of securing 50%. But that other part I am not going. I am only on these two parts. 17/4, the Honorable Supreme Court did not allow this continuance to non-teaching staff. Supreme Court only allowed it for the teaching staff, 9, 10, 11, 12. And this 21/8 order, this further relaxes, not for everyone, but for selected and appointed plus untainted. It's not that whoever participated in 16, they are going to get the same benefit. In that light, if Lordship kindly take it the same thing, the order passed in the review of Boishaki by the Honorable page 502. Sorry.
Fourth volume, volume 4.
Yeah, exactly. Page 502, this is the order. The order starts from 507. 7 naki eta dekho to. My 2. Oh,
501 it
fi-
starts.
Lordship is saying 501 is the last page.
It's the first page. It starts with order.
Yes, but that one. So kindly come to this 501 is the order passed in review. Kindly come to 502.
Yes.
502, my lord, somewhat after 10 lines.
Yes.
Little right hand side, however the interest.
Yes. Yes.
However the interest of the, kindly mark again, the same thing. Appointed candidates who were untainted were sought to be protected to the greatest extent possible, as is evident from the concluding paragraphs of the judgment. No doubt, invalidation of such untainted appointments would lead to heartburn and anguish, which the court was fully conscious of. But protecting the purity of selection process is paramount and necessarily has to be given the highest priority. Last but not the least, the adverse remark made against the authorities concerned who were wholly, next word I am on, wholly and solely, because that's something institutional fraud minus the tainted, not attached by the Supreme Court also with us. Wholly and solely responsible for this entire imbroglio, adversely affecting the lives of thousands of candidates, untainted and tainted, were fully warranted and justified. And the last is Lordship's, this 2611, that's the last order when it was ultimately sent before your Lordship. This is volume 3, page 391.
Yes.
Similar here. The first two paragraphs I am not placing because it's not necessary for the purpose that I am saying. From the second page, it would be open, but that is also not necessary. After that, the High Court shall, however, ensure that none of the tainted manner. This is also not necessary because this is now well known and Lordship is doing it. Kindly take the next page, my lord. This starts from the High Court shall examine the matters. 392. 392.
Yes.
The High Court shall examine the matters uninfluenced by any of the observations on merits made by this court in the orders passed after decisions in Boishaki. And next, this is important. The High Court shall also be mindful of the fact that the untainted candidates in the past selection, this past selection is not the 16. This past selection is for who were allowed by the court based on that 17-4 order. In the past selections were allowed to sit for the selection test to be held afresh, and their candidature cannot be adversely affected. Because initially, my lord, I had a feeling that this past selection refers to 2016.
Is it not?
May I read? Initially, a couple of times I thought that exactly that. May I read? Because that was my impression. The High Court shall also be mindful of the fact that the untainted candidates in the past selections were allowed to sit. Kindly mark the word allowed. The Supreme Court did not allow everyone to sit. Supreme Court allowed it only for the untainted persons. And by an order of the Honorable Supreme Court, the Honorable Supreme Court also relaxed certain conditions for those candidates who were untainted but appointed. Because the circle is more. Circle is wet list, circle is participating, but from the bigger circle, Supreme Court only chose this benefit to be given to appointed untainted. Now, therefore, the word allowing may not have any meaning if Lordship reads it of 16, because in 16, no question of allowing anyone. Everyone was there. So, in that context, if Lordship read it, the High Court shall also be mindful of the fact that the untainted candidates in the past selections were allowed to sit because they were allowed just because this order was after Supreme Court allowed it, then they also sat, they could sit it after that relaxation for the selection test to be held afresh, and their candidature cannot be adversely affected by application of new rules. In any case, well, I would be making these submissions. My first submission before your Lordship is thinking of, there is a possibility of reading it otherwise. But there is a possibility. I don't say that there is no possibility. But then Lordship has to somehow drop the word allowed. Well, I also read that.
Why? If we do not drop, then what happens?
If Lordship doesn't drop that, then it becomes like this, that the High Court shall also be mindful of the fact that the untainted candidates in the past selection were allowed to sit. Now, question is, it is were allowed to sit is an adjective kind of, it's a character.
Were allowed to sit by virtue of the order passed on 3rd of April. It has to be
Yes.
read.
Yes.
If
yes.
you read it that way,
Yes.
then it's the
Yes.
same.
Yes. I want to read in that way. That by 3rd April, they were allowed to sit, and relaxation was not given to everyone. Relaxation was given, Lordship has seen in the previous order, those who were appointed lost their job and they are untainted, not everyone. So therefore, they were allowed to sit. So far as if Lordship reads it, because I was trying to understand, because in an interpretation, my Lord, in fact, every time if someone reads, leave 2-3 days, after that he reads, anyone might have a different interpretations. But as on today, my Lord, my interpretation is tilted towards the fact of allowing by the Honorable Supreme Court, and therefore this past selection is really not referring to the selection of 2016, but that selection where it is because of the Honorable Supreme Court, some persons could get a chance. That's the act of allowing happened. So I would make an interpretation in this way, that the Honorable Supreme Court wanted couple of things which are required to be taken into considerations by your Lordships. Thing number one, it is not the orders after the main order. It is the main order, that is the 3rd April's Boishaki's order, not the subsequent order. But even if Lordships look at the subsequent order, that 17-4, where Lordship has specifically asked question, that no advantage, that advantage was from April to 31st December, not the advantage of the for entire 5 years or whatever number of years. In any case, This order, I would say that the Honorable Supreme Court, all that wanted that we have allowed some candidates, and while allowing that candidates, we have also relaxed certain conditions, despite the rule requiring otherwise. Lordships need to just consider that. I put it in, I put it that only. Therefore,
the commission ought not to do anything so that the candidates who have been allowed to be permitted to sit in the fresh selection gets debarred or becomes ineligible for participating.
I exactly this. Whoever Honorable Supreme Court has allowed, Lordships be required to just take into account that. It's not that the Honorable Supreme Court has in any way say that it has to be in this direction or that direction. Thus, take note that this is we have allowed. That's all. So therefore, if there is a kind of if Lordship, if I go back to that 17.4 observations, because this was an quite submissions showing 17.4, that is at page 230, that we clarify this order shall not be read as conferring any special right and advantage. So if I can sum up this submission, this order in the context of a temporary continuance and temporary continuance only, and this order has got nothing to do with whether in the rule a prior teaching experience can be said to be some constitutionally invalid advantage being given to others. That's not even the I would say context or anyway intended by the Honorable Supreme Court. That's I thought I should. This is my answer to that. Now, my lord, I would go to the rule itself that possibly Lordship is seeing the copy of the rule from separate 2025 rule. No, I have the copy, but Lordship must be
I have
from the day one. Lordship was marking it.
Yes. It রেখে দিন তো।
Number 346.
Because the marking pages, my lord, if that is not found, I think we lose track actually. And there lies, as I often say, there lies, my lord, in three-dimensional. For an example, I can, like this page, I know it, what is the middle of it. So I know it is not going to be a very heavy document. So therefore, even if I am partially blind, I can come somehow the middle of it. But if it is in the lesser dimensions, that now in the iPad, there, whether it is 50 pages or it is a 500 pages, now I don't know.
Yes, the rules.
Yes, rules. On the rule point, there are three issues. Issue number one is whether prior teaching experience itself is unconstitutional and violative of Article 14 or not. Now, some person
argued
exactly exactly that's what I was about to say, that this issue has substantially been argued, and I also made some submissions, so I don't want to say anything on that. So I just wanted to say what is that, and I would make submissions what is left over only. Now the other, there are two issues, that assuming that this is valid, if it is valid, then interpretation is always open. Then it is in accordance with the rule itself. Now there are two possible interpretations from two sides. The one side, that the petitioner sides are of the opinion that the rule,
freshers.
Yes, freshers. I put it freshers. Of course, they feel that the rule says it should be included before the interview list is prepared. Whereas that we who are not the freshers, our interpretation is no, it should be It should be,
It's just the opposite. They want it at the time of final merit list and you want it prior to the
yes, sorry.
interview.
They wanted that it should be done at
Later on.
the end.
Mm.
Now we say that
It should be done now.
it should be done now. Now my answer to what the rule says. Well, I would say from two stages. I would say if the rule becomes intra vires, which is the assumption now, then whatever the rule says, even if well, sometimes it rule might look good, it might give somehow, we might think it is there is a better way of doing it, but if the rule itself is that so, then it has to be done in accordance to the rule itself. So my endeavor would be that rule says it should be included prior to preparing this interview list. Why I am saying so? I am saying so because of the two reasons. My reason number one is there is a substantive provision in the rule which says that interview list should be made on the basis of what? Number one. Number two, that substantive rules also refers about schedule which has a sequence and the buckets. And number three, same substantive rule with a different provisions also addresses where the merit list has to be made. Therefore, interview list and the merit list being completely two different things operating separately by the substantive provisions, there any stretching of interpretations based on the interpretational clause may not be proper. May I just show this and I will straight away go to the judgment on this my proposition. I say that the substantive provisions, I said the substantive provision is, kindly take 11 Roman 8.
Yes.
The Central Commission shall prepare and publish in its website a preliminary list with details of candidates to be called for interview. So therefore, this is clear, to be called for interview, subject to verification of credentials and eligibility category wise on the basis of, now this is the bone of contention, on the basis of preliminary merit score as defined in Rule 2(1)K and K alone. Therefore, my respectful interpretation would be 11(8) is an absolute clarity how this list for interview has to be made. It says that it has to be made on the basis of the preliminary merit score. I would say, so therefore, it has three pillars. One, pillar number one, for what purpose? So answer is the purpose is the interview. The pillar number two, on what basis? The basis is preliminary merit score. And pillar number three, it refers to which? Then it refers to Rule 2(1)K. Now this substantive provision, when Lordship look at with the schedule itself, Lordship gets the sequence. Kindly take my schedule 2. So schedule 2, the sequence is number 1, written examination. This has taken place. So it was in the sequence, it is number 1. Number 2 is the academics that I have referred as a bucket. Now educational qualification, it is not number 3. It is something, a component within the bucket of the academics. And there, my lord, this marking, and that is small a, and then small b. So therefore, kindly see thereafter number 3. So sequence is number 1 equals to written examination, number 2 equals to accumulations of these under small a and small b, Number 3 equals to oral interview, for which a list has to be prepared. And number 4 equals to lecture demonstration. So therefore, under schedule 2, this sequence, it clearly matches and very much in sync with the definition as well as the substantive provisions. Now, only problem, if I can use the word, only problem or the point which can be said is that in that case, what meaning I give to the definition of the merit list, because that can be one of the very reasonable submissions. Lordship, may kindly take the definition of merit list. Because that is, this definition is that their entire, if I can use the word, entire oxygen for demonstrating that it should be post, not pre. My lord, my first submission is the stage that Lordship is interpreting is whether it is pre or post for interview list. Substantive provision does not refer for anything of the merit list at all. Sequence also gives a clear clarity how it is to be done. Now, in that context, if I read merit list, in respect of SLST, such and such means, in case of posts, a list of candidates prepared category-wise on the basis of merit, it shall mean, in addition to what has been stated in Rule 21K, marks obtained in oral interview, lecture demonstration, and prior teaching experience, and shall not include all the, this is not relevant. It doesn't talk about the sequence first. It's like, what is a merit list? So it gives a definition of merit list, whatever has been said in addition, because ultimately when the merit list is to be there, that will contain everything, because that will come later on. If I read it once more, my lord, for my understanding, I would read this way. First, merit list definition does not say anything regarding how to prepare the interview list, number 1. Number 2, it says that merit list in respect of SLST such and such means, in case of post, a list of candidates prepared category wise on the basis of merit. Kindly pause for one moment. So therefore, merit list simply means whatever is prepared on the basis of merit. Now, pausing for a moment, if Lordship have a comma here, now what is merit? If I answer in this way metaphorically, merit is A to Z. Instead of saying A to Z, they have said it means, it shall mean, in addition to what has been stated, because it is stated about the interview list in Rule 21K, marks obtained in oral interview, lecture demonstration, and prior teaching experience. Now, this is the troubling part. This is the troubling part, that and shall include all the eligible candidates. So that means, kindly look at this point of view.
Keeping in mind the submission of the petitioners that if prior teaching experience was not mentioned in the interview list, it has been mentioned for the first time in the merit list. So it should be taken up for consideration at the time of preparation of the merit list. Otherwise, you have to give benefit twice. In the interview list stage also, you are giving the prior teaching experience marks, as well as in the merit list stage also you are giving.
But that is, firstly, that is it cannot be, because then this sequence in the schedule has to be broken. It cannot be. One of the, in my understanding, harmonious way of looking at it is this, that for, if I go to schedule, then Lordship will get it. This is one rule under the schedule, also for 9-10, also for 11-12, and also for upper primary. Now in upper primary, in the sequence, the prior teaching experience comes last. So therefore, it is like one rule which has thought to be different for different sectors. I'm not for the time being on right or wrong. All I say that what the rule itself. So therefore, for A and B, that is for 19 and 11-12, there is a one stream which is pre. If Lordship kindly have a look at the sequence in upper primary under C, kindly come to schedule. Schedule, there are, my lord, three, one capital A, capital B, and capital C. Kindly take capital C.
Yes.
Capital C, selection to the post of assistant teacher for upper primary level. Lordship need not read. Kindly straight away come. Kindly see the sequence. Number 1, academic score. Number 2, TATE weightage, which is the difference for them. Number 3, written examination. Number 4, oral interview. Number 5, lecture demonstration. And number 6. Therefore, the rule it is one, which is trying to give some definitions for 2 separate categories. Keeping that in mind, if Lordships kindly come to the definition itself. Kindly come, my lord. Now, here is the role of rule 2.1 itself. That in the rules, unless the context otherwise requires. Therefore, my humble submission before Lordship would be this. This is one rule for 2 different categories. I would say 3 different categories. Under 3 different categories, they have chosen to go for 2 categories in one directions and 1 category in a separate directions. But they have chosen to give one definition for everyone. So while giving the definition of the merit, all they wanted to say merit equals to A to Z. Meaning thereby, merit means whatever we have said before plus ABCD which are applicable. In case there is a conflict, the answer lies, Lordships are required to see first whether, because for every definition it may not be there. First is this definition has to be used unless the context otherwise requires. Therefore, if the context is, here the context is the SSC is preparing the interview list, what they are required to do. My humble answer would be they are required to see what is the rule and they are required to follow that. And the answer is for that, my lord, the rule 11, that is to be followed. And once that is followed, Lordship doesn't find the definition of merit coming into play. Now, one apprehension may come. Does it mean that they will get again marks? My answer would be no. Why it is no? Because the sequence and the schedule has to be followed, number 1. Number 2, even if there is a conflict language-wise or otherwise, then it is the substantive provision which is required to be followed. And for merit, if Lordships kindly once more come to 11.8 equals to today's situations. That's the interview list, 11.8. Now, there is a separate situation also for the merit, that is Roman 16.
Yes.
Kindly see post-interview. After interview, the interview board shall forward a detailed report to the Central Commission, which shall form the interview list, and on the basis of the report of the interview board, prepare, publish a merit list, categorized on the basis of the merit as per Schedule 2. The moment, kindly, my lord, see this part, as per Schedule 2, I would read this way, as per Schedule 2, A, B, or C. The moment it is A, B, and C, there is no scope of going differently or double, because A has single, B has single, and C has single, but differently. For A and B, it is similar way. For C, it is last. Well, to that, there is a judgment. Judgment copy. No, it's okay. Well, at first judgment, upper. This is, yes, 1985 SSC Online, Bombay 256. I shall be relying only two paragraphs, 22 and 23. This is for the purpose unless context otherwise says. According to my submissions, it doesn't. But in case, my lord, there is any iota of conflict being there, then my lord, the interpretation is this. Paragraph 22. Francis Benyon in his treatise Statutory Interpretations 1984 such and such page, whether the defining enactment says so or not, a definition applies only where the contrary intention does not appear. I am only on that part. This is because the legislation is always free to display a definition. Sorry. Disapply. Correct. Because the legislator is always free to disapply a definition, whether expressly or by implication. Lordship need not read the others. Kindly come to 23. It is precisely to meet such contingency, the definition clauses invariably limit the scope of the definition by using the expression unless the subject or context otherwise requires, or some such qualifying words as laid down in such and such. The interpretations clause should not be understood as requiring, now this is the point, it should not be understood as requiring extended meaning in all circumstances, for the definition clause itself says unless the context otherwise requires. However, even where such an expression is employed, it is only where the contrary intention appears from the context that the definition clause may be given a go by and the word understood as is understood in common parlance. But then, as stated above, when the definition, that's not. In this context, Lordship will not find a different intention is appearing in Schedule 2 or in Rule 11. Absence of merit list in Rule 11 is the clarity to follow Schedule 2 sequentially. Well, next is 1980, 1 SSC 321. Only one paragraph, paragraph 24. Paragraph 24. A definition clause does not necessarily in any statute apply in all possible contexts in which the word which is defined may be found therein. The opening clause of section 2 of the Principal Act itself suggests that any expressions defined in that section should be given the meaning assigned to therein unless the context otherwise requires. Well, there is one more judgment. Okay, two more. Mothu, well, 9. Well, there is one judgment. This is the Vanguard fire. This is not reported. It is taken from the Honorable Supreme Court's website. This is a copy. Copy. Paragraph number 5. Sorry, this is not paragraph because there is no paragraph number. There is page 5. SLP number to give. Well, from it is well settled that it is there is one first paragraph. Lordship may skip. Thereafter another. It's referred about section 33. Lordship may skip.
It is well settled.
Yes. It is well settled that all statutory definitions or abbreviations must be read subject to the qualifications variously expressed in the definition clauses which created them. And it may be that even where the definition is exhaustive, inasmuch as the word defined is said to mean a certain thing, it is possible for the word to have a somewhat different meaning in different sections of the Act, depending upon the subject or the context. That is why all definitions in statute generally begin with the qualifying words similar to the word used in the present case, namely, unless there is anything repugnant in the subject or context. Therefore, in finding out the meaning of the word, here context was insurer, in various sections of the Act, the meaning to be ordinarily given to it, it is that given in the definition clause. But this is not inflexible, and there may be sections in the Act where the meaning may have to be departed from on account of the subject or context in which the word has been used, and that will be given effect to the opening sentence in the definition sections, namely unless, well, that part. So the last one is 1997 to SSC 53. Paragraph 12 and 13. Paragraph 12 and 13. Where the definition or expression as in the instant case is preceded by the words unless the context otherwise requires, the said definition set out in the section is to be applied and given effect to. But this rule, which is the normal rule, may be departed from if there be something in the context to show that the definition could not be applied. Why I'm making these submissions? Because my understanding is the merit list equals to A to Z, all, no repeat. By stretching the definition of merit, if an interpretation is sought to be made that it would make a twice prior teaching experience, Lordships can very well, even if there is a conflict, Lordships can very well take that interpretations, saying that I would not go only with the definition of merit itself. I will take merit as whatever has been said above plus whatever is left over. That is, merit equals to all and the preliminary equals to whatever said before that. And 13 is, this court in such and such case, while considering the definition clause of the Act, which is under our consideration held, a definition clause does not necessarily in any statute apply in all possible context in which the word which is defined may be found therein. The opening clause of section 2 such an itself suggests that this is the same thing which has been said. Well, on this topic, there is no other judgments. Now, I shall be placing the judgment on the directly on prior teaching experience point. My first judgment that it is valid. First is Sachibala.
Quite a few has been referred possibly in Orunima, Paul.
Which one?
This prior teaching experience is permissible. It is perfectly done. No issues.
Yes,
The others have also referred to.
Yes, division. What I am trying to address it that because I thought that I would be ending with that this rule was challenged. The point of prior teaching experience was also canvassed before the honorable single judge. The fact of challenge of the rule was given up before the honorable division bench. Prior teaching experience was canvassed. The honorable division bench also there is one detailed paragraph that it is okay. Experience is something intelligible differentiate is there, that is expressed there, and ultimately it's not that it was interfered by the honorable Supreme Court. But I was also making an effort, assuming nothing is there. I was, because it's not an interim purpose. Lordship is going to deliver a final judgment. Of course, that's one of the good points in our favor. Leaving aside that also, when Lordships look at the issue as if it is absolutely a fresh issue which has not been touched by any court before at all, even then, there is an every possibility that Lordship might echo with the same saying that Malady, I would put it in this in this simple words that once there is a recognition that experience is different, the fact of some weightage being given to that experience, irrespective of the fact that that causes the competition becomes harsher for some others or it becomes tougher for the freshers, Lordships may choose not to interfere with in the light of the Article 1416 by saying that there are differences. Some people have more experiences, therefore they get weightage. You become a better student and you fight in the dominant factor of this. On that context, yes, Lordship is absolutely right. In Orunima matter, division bench have said so. I have that judgment also. But this is the judgment where 2017 11 SSC page 421. On past service point, straightway paragraph number 21. If
Which paragraph?
yes,
is it?
paragraph
21.
paragraph 21.
Yes.
Before that, for lit, but I think I'm trying to go to the exact paragraph. So therefore, paragraph 21, the first respondent who was a party to the settlement recorded by the High Court in its order dated such and such could not be permitted to raise the question of enforceability of the settlement, more particularly when all that the appellant seeks is only weightage for the past service of its members, which the first respondent agreed. In principle, I'm on the in principle point, to give to similarly situated persons working with other departments. The members of the appellant union have been working with the first respondent for long periods, period varying from such and such. Whether such employment was regular or irregular in law is a different matter. Well, because there was one of the submissions from petitioners was the Honorable Supreme Court declared it to be void. Does it mean that our act of teaching, or if I can say this, does it mean also that our entire experience also becomes void? My first answer is the Honorable Supreme Court have actually, while dealing with untainted, with two categories, kept even the past service who had an old job and allowed us to participate. And in that context, state chose to make a rule to give an weightage to all the persons whoever has got the past experience. In my understanding, my lord, that does not violate at all. My lord, next judgment is 2024 SCC online SC 3540. It was by Justice Dotto and Justice Mahadevan. Paragraph 29. The context can be found from, I'm not reading all paragraphs, 25, 26, 28, but ultimately Lordship will see that very short, as we are applied to the constitutional mandate prescribed in Article 14 and 16 read with a preambular promise of securing social justice, we hold that non-grant of mark for experience to the first respondent was not proper and legal. So therefore, there was an affirmation. Next, whatever. But this is, Lordship may also kindly take 28 also. In this case, for the foregoing reasons, refusal to award any mark for experience to the first respondent would go against the grain of the constitutional duty of ensuring equality and securing social justice for the deprived. My lord, next judgment is 2018 13 SCC 560. Paragraph 33. (2018) 13 SCC 560, paragraph 33.
Yes.
Question now is whether in the absence of any right in favor of Shikha Mitros, they are entitled to any other relief or preference. In the peculiar fact situations, they ought to be given opportunity to be considered for recruitment if they have acquired or they now acquire the requisite qualification in terms of the advertisement for recruitment for the next 2 consecutive recruitments. They may also be given suitable age relaxations, which has been given to us also, some of us, I would say, who required it, and some weightage for their experience as may be decided by the authority concerned. This is not a case where there is a rule itself. All I'm trying to say, there is a recognition of experience and thereby some consequential benefit which can be given without affecting Article 14, only that part. And then this one. This is this is clear cut 2016 SCC online Rajasthan 646, paragraph 6 first. Before coming to the facts, it would be appropriate to mention that the concept of equality enshrined in the Constitution of India does not forbid reasonable classification for the purpose of legislation. If any classification is made which is founded on an intelligible differentia, it distinguishes persons or things that are good together from others left out, and the differentia may possess a rational relation to the object sought to be achieved by the statute in question, then that does not offend the concept of equality. The concept of equality does not take away the authority of the state to classify the persons for legitimate purposes. If a law deals equality with members of a well-defined class, it is neither obnoxious nor a denial of equal protections given under Article 14 of the Constitution. Thereafter, my lord, a 5-judge bench of the Honorable Supreme Court in Chiranjit Lad was referred, same page, paragraph 7. I'm not reading it, the last paragraph. Lordship may kindly mark paragraph 7, the last portion in Chiranjit Lal versus Union of India. That's a constitutional bench judgment. After that, ultimately, thereafter, paragraph 12. In view of it, we are of considered opinion that the persons having experience on similar work under the government, National Rural Health Mission, and Medicare Relief Society form absolutely a different category. And the classification made under the proviso impugned is not at all discriminatory. This was upheld by the Honorable Supreme Court. Tell me paragraph. Last one, 2021, 15 SSC 401, paragraph 61. Before that, Lordship may also kindly take paragraph 54.3. Should sorry 54.3 and 61.
Yes.
And this is directly, the question was freshers versus someone who was working. 54.3, should there not be a different yardstick for Shikha Mitros who had been rendering services as teachers as against what could be applied for fresh graduates? Now, in that light, the answer is at paragraph 61. Relying on the decision of the court in such and such, it was submitted that Shikha Mitra who had been discharging their services as teachers could not be put at the same level with fresh graduates having such and such qualifications. In that case, this court was called upon to consider setting aside of certain seats of the state government for in-service candidates in postgraduate courses. It was observed by this court, thereafter, this is a quote, and Lordship may skip that and kindly straight to come to last paragraph of the same page. This court was considering validity of certain percentage of seats earmarked for in-service candidates, and it found the classification to be correct, having nexus with the object of ensuring availability of competent professionals in the rural parts of the state. On the other hand, the object of giving opportunities to Shikha Mitros was to ensure that they are given fair chance to compete with others so that the best of the lot would be available to take care of primary educations in the state. In our view, the submission does not deserve acceptance. Question C set out such and such is answered accordingly. Well, these are my judgments on prior teaching experience point. Next is having participated. Having participated. Physical. Well, first is 2019.
Which proposition?
Yes. Well, all of them, they have participated.
And now they question the selection process.
Now
and
they
the-
have, Lordship may look at from two views. One is they are questioning the constitutionality. The other view is, while questioning the constitutionality, they are also questioning the method of the recruitment. Because the marking was well known to them. They participated. Now they are. So in that context, I want to say, having participated and knowing fully well about the method, now possibly they cannot question it now. In that context, first 2019, 15 SSC 633, paragraph 21 and 22. And 22. Paragraph 21 and 22. First 21. There is one more aspect of the matter which need to be noted. The applicant was well aware that under 30% LDC quota, out of 5 vacancies, 4 are unreserved and 1 is reserved, which was circulated by notification dated such and such. She applied the said bifurcated vacancies and was interviewed on such and such, panel of which was declared on such and such, and promotion was made on same day. She, having participated in the selection for promotions under such percentage quota and bifurcations of the vacancies, being part of the process of selection, it was not open for her to challenge the bifurcations of vacancies into general and reserved after taking a chance to get selected. In this context, reference is made to judgment of this court in Ashok Kumar versus State of Bihar. Then, my lord, the court, the law on the subject has been crystallized in several decisions of this court. In Chandraprakash Triwari, this court laid down the principle that when a candidate appears at an examinations without objection and is subsequently found to be not successful, a challenge to the process is precluded. The question of entertaining a petition challenging an examination would not arise where a candidate has appeared and participated. He or she cannot subsequently turn around and contend that the process was unfair, or that there was a lacuna therein, merely because the result is not palatable. In Union of India versus Binod Kumar, this court held, it is also well settled that those candidates who had taken part in the selection process, knowing fully well the procedure laid down therein, were not entitled to question the same. But in fact, I would not read the entire paragraph because it is same propositions spread over everywhere. Lordship, ultimately 22 with us, due to above both reasons, are of the view that the tribunal and the High Court ought not to have entertained the scale claim of the appellant. Well, on this proposition, my next is 2013 11 SSC 309. Paragraph 18, 19, 21, 22 and 24. I shall be referring to paragraph 22. I shall be reading 22, referring all, but not. I am reading only one paragraph, but I am relying the all others also. 22, in Manish Kumar Shashi versus State of Bihar, the court reiterated the principle laid down in the earlier judgments and observed. We also agree with the High Court that after having taken part in the process of selection, knowing fully well that more than 19% marks, this is the, here it is 10 marks, more than 19% marks have been earmarked for viva voce test, the petitioner is not entitled to challenge the criteria or process of selection. Surely, if the petitioner's name had appeared in the merit list, he would not have even dreamt of challenging the selection. The petitioner invoked jurisdictions of the High Court under Article 226 of the Constitution of India only after he found that his name does not figure in the merit list prepared by the Commission. This conduct of the petitioner clearly disentitles him from questioning the selection, and the High Court did not commit any error by refusing to entertain the writ petition. The same proposition. The other judgments on the same propositions is 2017 9 SCC 478. Paragraph 4, 6, 8, 10 and 11. I would be referring all, but I shall be reading only one paragraph, paragraph 11. As far as the present case is concerned, an advertisement was issued by respondent number 6 inviting applications for the post of music teacher in such and such school. Respondent 1 did not raise any objections at that stage that the post could not be filled in by direct recruitment and she should be considered for promotion. Not only that, she is in fact applied for the post and took part in the selection process. After having taken part in the selection process and being found lower in merit to the appellant, she cannot at this stage be permitted to turn around and claim that the post could not be filled in by direct recruitment. The reasoning of the learned single judge in rejecting the objection is not in consonance with the law laid down by this court. In view of this, we need not go into the other issues raised. The last one is 2022 1 SCC 294. This is by a larger bench comprised of 3 honorable judges. 2022 1 SCC 294, paragraph 35, 36, 37 and 45.
30, please repeat. 35.
35, 36, 37 and 45.
Yes.
Well, I'm not reading it because it is
Reiterating the same thing.
Yes, same thing. But only purpose of this for 2, that this matter being even had it been any other matter, maybe I would have brought only one judgment, so that my sentence
Consistent view of the
that I'm not picking up and saying that I got a judgment and therefore I'm placing. No, this is the consistent view. So only that purpose.
কি কথা বলছো এদিকে? The clock is ticking.
Yes. Well, I might take just 10 to 15 minutes.
Another 15 minutes.
10 minutes, because I have almost finished. I would wrap up with 2 things. One is that Orunima, in fact, that I have with me. And I might take just 5 minutes to sum up, and not 15 minutes by clock.
May I request only because I believe all parties are.
1 minute. Tell me one thing. The commission is here. Whether the disclaimer has been published.
Yes. Or another thing is substance.
Because this is troubling the court. The time is going. The 31st is the date. Nobody knows which side it will tilt. It involves thousands and lakhs of candidates participating. The commission should keep the data ready. I will require the data, the number of candidates participating, the freshers, the old ones, and everybody. The percentage, how have they fared and everything. For giving a proper judgment, these data may be required. As and when stages come, these ideas come to your mind. I cannot offhand say, but then since the arguments are advanced. I have to think over
In
it.
fact, I would be also requesting Learned Advocate General to have the statistics that by percentage wise for out of total 35,000, how many freshers have got and
Yes.
how many, so that some rough
You will
idea.
not be able to say the commission.
Yes, yes.
Yeah.
No, sorry.
The commission will say.
I just,
If they make it
Correct.
in a tabular form that
Yes.
in
yes.
each and every subject
Right,
matter,
right.
give an idea without,
and another
It will be easy.
yes.
Everybody also
Yes,
gets to
yes,
know that
yes.
this is the picture and why this judgment is coming. Otherwise,
Right.
various questions
Correct,
nowadays.
correct.
Why
Yes,
this?
yes.
Why not this?
Yes, true.
and another thing, substantial amount
Correct.
is taken.
Substantial amount.
Substantial amount of time already taken by the all the
Parties.
parties because if everyone is agreed on it, make it part only. Otherwise, if
Yes, 100%.
I have
We can't afford
mentioned it on the last occasion that the court has consumed a lot of time in this
we would
matter.
be doing an
Assuming
injustice.
the bench
Yes.
gets changed,
Please.
it will be an
Take it as a
understanding that
partner.
it has been substantially hurt by this bench. Now, if somebody says no, it has to go, it will go. Certainly, a court cannot hold on to the
I
matter.
want it because I have spent lot of time. I understand the pressures judicial. Kindly treat it as a
Judicial hours, valuable, very
Yes,
valuable
yes,
judicial
yes,
hours have been spent on this.
So
I'm
kindly,
not recording heard in part. Let's see what happens.
Lordship can record it. What is the
otherwise, we both the parties agreed, my lord. Or
No,
by
it's not.
consent.
No, it's not both. There are many parties.
Commercial, every party.
There are many parties. I'm not recording it formally,
No,
but then let it be
in case anything happens, or
considered.
if
Yes.
that-
In case there is change,
Yes,
in
yes.
case there is no change, it's going on. I do not know whether there'll be a change or not. Nobody knows.
Indulgence I will be playing because I am in a situation that possibly tomorrow my turn will come. But I have fixed two matters tomorrow, at least 2 weeks back. One is fixed at 2 o'clock, the other is fixed at 3:30.
Morning. Morning.
I should inform the court that tomorrow,
Difficult for you.
because I cannot finish in a half. Otherwise, another starting of course, the other business.
Other matters have to be given some amount of time. The entire second half is consumed here.
Could your lordship accommodate me the day after tomorrow?
Let us see. Day-to-day hearing will be
Yes.
possible or
If the
not.
situation comes
Yesterday,
that
I didn't take up this matter. I kept at least one day in between to take up other matters.
Well, in one matter, this opposition, there was a little delay, so kindly one line.
I will condone the delay.
No, there is.
I will not take it as a delay. I'll permit
Yes, that.
those documents
That is in item
to
60.
come in.
60?
1 minute. Let me first
Yes,
think
yes,
as to when will be the next date.
না, 61 টা
Item 60? My mind and the calendar
Yes.
are not in the same line.
OMR published ইস্যুটা কালকে আছে না
Uh,
my lord, item number 61, that is Moshumi Mondol matter, my lord. There is a 261 Moshumi Mondol that went up to the Supreme Court, my lord, and Supreme Court freshly is taken up by this bench, my lord. Till date, already, my lord, pass an order to publish the 2025 OMR sheet. Till date, they not publish it, my lord. Same prayer in Moshumi Mondol also, my lord. It will be kind enough. The matter will came up tomorrow, my lord. That matter, my lord. It will be kind enough posted this Moshumi Mondol item number 61 tomorrow, my lord, along with others, my lord, prayer.
all right. If there's an exception, the court will certainly hear. Please come. Are you a party in Lubana?
Yes.
Because I did not see your appearance on the last occasion. In Lubana, you are not there.
Lubana, I
All
am
right.
not.
All right.
I mean,
I indicate one thing, my lord. Lubana is filed because that having participated and rule can't challenge, but Lubana is filed much prior. Just immediate framing of the rules. Lubana and Moshumi Ghosh.
Are the first matters?
Yes, madam. Lubana and Moshumi Ghosh, Ghosh Das, both the matter filed just immediate after the publication of the rule, my lord.
Lubana was filed at the time of Odunima's time. My lord, Odunima was heard, but Lubana was left.
All right.
Lubana and Mosumi Ghosh Das, both the matter, my lord, file at the
Moushumi Ghosh Dash, which item is this?
item number
Item number 62.
62.
62. Yes.
And there,
12,000.
thereafter, my lord, Bhim Sarkar and Choitali.
That is after fresh candidate. ঠিক আছে। Hard submission recorded in Lubana. এই যেটা হচ্ছে 56. Hard submission made on behalf of some of the job losers, untainted job losers.
Not specific like that.
Who participated in the second SLST 2025. Stop. Fix the matter for further hearing on. I'll take it to the 6th of January. Yes.
Then make it for one line, one make it patad, my lord. My lord, with all the parties, my lord, agreed on that one. because
Don't worry, it is part heard, but then I'm not recording it.
Then my lord, item number 61. My lord,
এটা কে দিয়েছে? এটাতে 56 এ নেই, সেই জন্য দেয়নি।
পুরো বান্সটা।
That can be tagged together.
my lord, they are in
Lubana,
my matter.
let the petitioner say,
My lord,
then
my matter.
respond whether they are in the same lines or not.
My lord, I just to give the number. 56 Lubana Parvin,
Hmm.
59 Bhim Kumar Sarkar.
Before that, 58 also.
That is not my matter, so
No,
I
that's why, but
could.
I'm
Shishir Rahul.
1 minute. Shishir also.
yes, but I'm appearing also.
আচ্ছা তাহলে 56 57
No, my lord, 60 except 61. Except 61. 61, my lord, to put it tomorrow, my lord.
all right 56 57 58 59 60 and 62 except 61 update in one order in that case.
Affidavit.
Some of the job losers will all right, so that will
63 also where
আপনার সেই আইটেম নাম্বার দিকে পাঠিয়ে
আমাদের বিশ্বজিৎ আছে।
ওরকম ভাবে কি রকম ভাবে যে
Up to 62 except 61.
up to 62 except 61 one item one order is being passed which
Yes.
will cover all.
কেন হয়েছে?
6th of January 2026. You have difficulty this week and then the court's time may not permit. That is the reason. Now 61 will be there in the list tomorrow.
Tomorrow, yes.
All right. And 63 onwards, let it remain in the list as and when.
63 is identical.
Oh, আচ্ছা, 63
opposition.
63
I am for the
order
petition.
record. Which applicant?
applicant number 2 can 2.
Acha. Affidavit in opposition filed on behalf of the applicant in can 2 taken on record. It will be open for the petitioners to file exception to the same. Prior to the adjournment. Item numbers.
দিবে কপি দিও যদি আমাদের
Actually,
58, 59 and 60.
filed by the commission. Please circulate copies.
And I keep 63 also with this bunch.
Fine. এরাও পাঠিয়েছে
63 বলছে এই বাঁচে
63 also keep
63 I am for the petitioner.
This issue is, my lord, the
11th.
my lord, the
different issue.
yes. 63.
This is also regarding giving of 10.
63 is the 10 marks or that 19 school
Are you the
teacher.
petitioner in 63?
Yes, yes.
Let it be separate.
He is the petitioner in
It is
63.
63.
This is also rule
Answered.
9,
There
10,
is
11,
no
12.
challenge, but then whether 9, 10 experience.
Yes, yes, yes. That is.
That's
For 11, 12.
He has not
This
challenged.
issue has not been challenged in the other ones. 63 is separate. Yes, sir.
58.
64 onwards will remain in the list as it is. Your matter has been tagged up.
58 and another is not in the list that I had done yesterday.
Let it come. I am keeping matters in a staggered manner, so everyone can come in.
I found a different issue.
All right.
Okay.
All parties.
Respondent. নাম্বারটা দেখে নিতে হবে।
61 টা লিস্টে কালকে থাকছে and 63 না 63 অর্ডার হয়েছে হ্যাঁ you want কিন্তু তাহলে তো ওর ইয়েটা সাবমিশনটা তাহলে কোথায় রেকর্ড করা Sixty-three opposition has been filed. You can file your reply. Whoever the petitioner is, you can file your reply. I'll fix it on the 6th of January.
yes.
Exchange all your pleadings.
না না আমার যেটাতে